Welcome to the New York Business Leaders Podcast, presented by the Coyle Group. We interview the most interesting and influential business leaders in New York and hear their stories of success, challenges, and lessons learned while building their businesses and personal brands. New episodes drop weekly, so please be sure to subscribe to get updates on your favorite stream. Without further delay, here's your host of the New York Business Leaders Podcast, Gordon Coyle.
Welcome back to the New York Business Leaders Podcast. I'm your host, Gordon Coyle. In this episode, I welcome my friend Michael Steger to the show. Mike is a trademark and copyright attorney who works with a variety of client types in entertainment, design, photography, software development, textile design, publishers, and many more, to help them protect their intellectual property rights. In this conversation, Mike breaks down what copyrights, trademarks, and patents are in the IP world. As always, thanks for listening to our podcast. I hope you've subscribed, and if you haven't already, please rate this show so others can find it on their favorite platforms. Lastly, if you have an interesting story and would like to tell it on this podcast, let me know. Drop me an email and let's chat. My email will appear in the show notes below. Thanks. Now, on to the show. Welcome, everyone, to the New York Business Leaders Podcast. Hello, Mr. Steger.
Hi, Gordon. Good to see you.
Good to see you too. Welcome to the show. Why don't you take a minute or two and just tell us about yourself and your practice?
Yeah. So I'm Mike Steger. I'm an attorney. I have my own firm based in New York City and with an office in Rockland County. And my practice focuses heavily on trademark, copyright, and entertainment law. And I handle both litigation and transactional matters in all of those areas.
So for the non-lawyers listening to the show today, can you give us a little bit about what IP law is and entertainment and trademark and how that works?
Sure. So intellectual property law focuses generally on intangible things of value. And there are three main areas of intellectual property law. The first is patents, which covers inventions, processes, new kinds of plants that you can develop, and those can be very valuable and can be protected. I don't handle patents, so I'm not going to spend any more time on that today. I know plenty of good patent lawyers, as you do, Gordon, and happy to refer those matters out to colleagues of mine. Now, I spent a lot of time on Trademark Matters, and what a trademark is something that identifies the source of goods or services that are provided usually by a business, sometimes by an individual. So this can be a brand name, such as McDonald's. It can be a slogan, which now I'm blanking on a good trademark slogan, but one will come to me. Or it can be something like a logo. So like the Coca-Cola script logo. Sometimes you see Coke with an R symbol at the end. That's a logo. The McDonald's Golden Arches is a logo. Trademark, as is the Nike swoosh. And what these trademarks have in common is they are used to identify the company that's providing the goods or services, and hopefully they create a connection in the consumer's mind so that when you see the Nike swoosh, you know that it's associated with sneakers and athletic apparel. When you see the McDonald's Golden Arches, you know what you're going to get in that restaurant, whether you like it or not. But you're going to get burgers and fries and drinks and ice cream that are not going to be that expensive. All right, so a copyright is any work, creative work, that is fixed in a tangible medium of expression. And things that can be copyrighted are written materials, a book, an article, computer software code, photographs, artwork, designs, audio recordings, music. And music is a good example of something that's copyrighted because you buy a CD. People used to buy CDs or albums like this. There are two copyrights contained in this CD. First is the composition or the song, which is the written sequence of notes for the instruments that are involved and the lyrics. And then there's a sound recording, which is the actual music as it's recorded. And for example, if I sit down at the piano and I just play a couple of notes, that whatever I'm doing there is not subject to copyright, just the sound that's coming out. Once it's recorded, then it's subject to copyright. So, I take my phone and I record what I'm doing. That would be a sound recording. Or I write down the notes that I'm playing. Once they are written down on paper, that is also subject to copyright.
Got it. So why don't you give us an example of a client that you may be working on or have worked with to demonstrate what, copyright IP infringement is about and what you try to do with that?
So you can get a copyright, as I mentioned, in designs, and this can include designs that are two-dimensional artwork. So over the years, I've had a number of cases where I am representing fabric designers, textile designers who come up with designs primarily for women's clothing, such as this. And the pattern here, copyright was registered by my client. And in the fashion industry, a pattern is popular. Other people may be inclined to copy that pattern. And if they do so without permission, and if the new design is substantially similar to a design that is already where the copyright has been registered, original copyright owner can pursue an action for copyright infringement.
Got it. So tell me a little bit about registering a copyright. What's involved with that?
The registration process for copyright is pretty simple. Of the areas of intellectual property that I had mentioned, trademarks, patents, and copyrights, copyright registration is by far the easiest process to get a registration. You have to fill out a form. You can either do it in paper or online with the Copyright Office. But if you file it by paper, especially now, it's going to take a very long time to be processed, where the online processing, takes no more than half the time to do a paper filing. And it's also less expensive to do it online. You have to fill out a form, which includes things like the name of the author, who originally came up with the copyright, the name of the copyright claimant, which the claimant is going to be the owner of the copyright. So many instances, if someone's employed at a business and they create copyrightable works in the scope of their employment, the employer will own the actual copyright. So that has to be included, the date of creation, whether the work is published or unpublished, and a few other things. And then you have to submit what's called deposit copies of the copyright, which are samples. Typically, those are done. So for something like this, the sample would be drawings of the original pattern. I do a lot of photography copyright. In that case, you have to submit copies of the photos, which are usually just uploaded and things like that. Then your federal rights relating to the registration will run from the day that the full application has been submitted, including the deposit copy. So it's not the date that the registration is actually issued or when it's approved. Your rights run back to the day that the full application was submitted.
Just kind of thinking about business owners, you mentioned this textile manufacturer or designer. What other businesses that maybe never have considered a copyright should think about a copyright, especially like when you consider logos and those sorts of things as well?
The logos would be for trademarks.
Okay.
Maybe we'll discuss that in a minute or two. But other areas where there can be a lot of copyright issues, publishing, obviously, with books, anything in the entertainment arena, all the works that are being created there are subject to copyright. Photography, and one area that's really ripe where there's a lot of copyright infringement is real estate photography, that the photographer will take photos and then brokerages will often use the photos without permission. Computer software can be an important area for copyright registration, although in that area, copyright only protects the actual code and protects against copying code. It does not protect against the function or what the code does. So you can design around the code and write different code that is going to do the same thing.
So let me ask you a question. If I took a picture of the Flatiron building and I had it on my Facebook page, and a real estate broker had a listing inside the Flatiron building and just searched it and happened to, come across my photo and there was some distinguishing feature and they used it, and let's say I copyrighted it, there's a lot of ifs in there.
Right.
Is that what you're talking about with regard to real estate?
Yes. So in that case, if you had registered your copyright prior to the infringement, you would be able to recover either your actual damages, which would be your lost profits, possibly the infringer's wrongful profits, or you could recover statutory damages, which can run up to $30,000 for non-willful infringement or $150,000 for willful infringement. And you'd also be able to recover your attorney's fees.
Got it. What about, I've heard that are some properties, like for example, the Flatiron Building, if I took photos of the Flatiron Building and then sold them as posters, does the building owner have a copyright interest in those photos?
There have been some cases over the years involving copyright in buildings, but the copyright owner that the building has will belong to the architect, and then whoever acquires the rights from the architect for the plans for the building. There have been other cases involving sort of commercial misappropriation of buildings in films, for example. And I'm aware of those, and I do not know how those cases turned out over the years. It's not an area of heavy litigation.
Yeah, okay, interesting. So let me ask you, in such a specialized field, how do you go about developing business opportunities for your firm?
There's sort of two ways. The vast majority of the work that I get is referrals from other attorneys. So over the last 16 years that I've had my firm, I've worked with a lot of other attorneys, collaborated with them. Sometimes I have good relations with attorneys on the other side of matters that I have worked with. And I know a lot of other attorneys who don't handle copyright and trademark matters that I've developed good relationships with. A lot of corporate attorneys, maybe patent attorneys who don't handle copyright matters, attorneys in other parts of the country that I know from bar association involvement, or even attorneys that I worked with 25 years ago. Every once in a while, I'll get a referral from someone who was at a firm I was at in the 90s. And some of that's just keeping up good relations with people that you've met along the way.
Uh-huh.
And then I also do, in the copyright area, I will speak on copyright issues to a more general audience, such as photographers or entertainment professionals, and give some presentations on copyright issues with them. And sometimes that will lead to some business.
Got it. A lot of businesses have seen change over the last 5 or 10 years. Has there been a significant change in your business practice or what you've seen in the way of your business over the last 5 or 10 years?
Gordon, you're asking about my firm as a business, not really the legal, not the substantive legal areas.
Correct. Right.
I've had some growth in the practice over the last couple of years, which I think in large part has come from having deeper relationships with other professionals. And also, I think if you have some success in some matters, that tends to lead to more work. And also, some of my clients over the years, my clients' businesses have gotten more successful, so they have more work for me at the same time. And I've also, with my business, tried to get more efficient over the last 5 years, trying to delegate as much work as I can to staff, so that I can really try to concentrate as much as possible on just substantive legal work and business development, and spend as little time as possible on administrative work and other areas that are not going to lead us directly to revenue.
Yeah, I think that's the goal of most business owners and professionals, trying to stay away from the paperwork and the admin work that drives everybody nuts.
Yes.
So on the reverse side of the successes that you've seen, what are the challenges that you face that you regularly see or may have shifted over the last several years? What kind of challenges are you looking at?
Challenges include just managing the workflow. In the past year and a half, there have been some challenges because some of the courts really slowed down because of COVID. And there were some issues there with trying to move cases along when maybe the court wasn't moving very quickly, or the party on the other side became very recalcitrant because they knew they were not going to face much downside from the court by dragging their feet. And then there are always issues with maybe clients go out of business, or clients sell their business to someone else who already has other lawyers. Those are always some challenges.
So Mike, we touched on trademarks just briefly. I'd like to come back to that. Is there any advice that you have for the listeners when it comes to trademarks, especially for business owners, we talked briefly about logos. What other issues around trademarks do you have advice on for business owners?
Well, there are two ways in general that you can file for a trademark in the United States. The first is what's called a use in commerce application, and that's if you're already using the trademark with the goods or services that you're trying to promote. So, for example, if you wanted to file a trademark now for the Coyle Group for insurance services and an insurance brokerage, you could do that as a use in commerce trademark because you're already using it. The other way you can apply is, say you come up with a really great slogan, and I have plenty of clients who do this, but you're not using it yet, but you're concerned as soon as you start using that slogan, someone else may try to copy it. You can file an intent to use trademark prior to rolling out the actual mark. And once that intent to use trademark is approved, eventually you do have to show that you're using it. But once you do, your rights in that trademark, your federal rights, will run back to the day that you file the application, not the day that it's approved. So that is a way that business owner, trademark owner can be proactive, gain some protection before they even start using the trademark. But with trademarks and copyrights and really any intellectual property, and much like insurance and other businesses, it really makes sense to talk to a lawyer who's knowledgeable in that area early on so that you can plan out what your strategy would be for protecting your trademarks. One of the biggest issues I've run into in the last 2 years or so is I get plenty of people who have copyright issues or trademark issues. They didn't file their copyright application, their trademark application. Somebody else is using the trademark that they want to use. They waited too long to file an application, and they're really in a tough spot. And typically, if we can start working on it earlier, it's going to be much more cost effective for the trademark owner to move ahead.
Got it. So that was going to be my next question is this is not a do-it-yourself sort of a thing, because there may be some pitfalls for the do-it-yourselfer versus strategizing it with an expert like yourself in this field, right?
Yeah, so the standard, if you can get a trademark, assuming everything else is clear, the test is whether it is confusingly similar to another registered trademark. And that confusingly similar does not mean it has to be an exact match. It means that it's something that if your new trademark is here and the existing trademark is here, is the average consumer, which is going to be the average consumer for that product or service, are they going to be confused as to what the source of the goods or services are by those two trademarks? So this can be things the names sound alike, they look similar, depends on a lot of factors there. And for most people, that's not something you can figure out by doing a search on your own.
Right. So take an example of a business owner that doesn't trademark their logo or their slogan, and somebody else has something, they're devious about it, and they develop something competitively that's similar, and then they file for a trademark. How does that wash out?
Well, the business owner who in this scenario, who was using the mark first, would still have what are called common law trademark rights. So they would be able to continue using the trademark in the geographic areas where they were already using it prior to the new applicant filing. But that new applicant would have exclusive rights to use the trademark anywhere else in the country. And I'll mention trademark rights run country by country. So if you have a trademark in Canada that's registered in Canada, that doesn't do you any good if you cross the border into Detroit. You need to register in the countries that you're actually looking to protect the trademark. Copyright, on the other hand, does have international protection under certain international treaties.
Got it. And with the internet, how do you say that I'm only using my trademark logo or slogan, just to continue on that conversation, in, say, New York, New Jersey, tri-state area, but you have a website and it's all over the country, all over the world?
Well, a lot of that depends on the type of business that you have. So if you're, let's say you're an online retailer, I can go to your website and purchase products and have them shipped anywhere in the country.
Right.
That would be presumptively, that's something you're doing nationwide. If I have a dry cleaner in my neighborhood that's just in that, is on a corner downtown in my town, that dry cleaner is only going to be providing services within a limited geographic area. It really depends on the nature of the business.
Got it. So, interesting conversation. Is there anything else that we didn't cover with regard to your practice, intellectual property, that you'd like to talk about today?
No, I think the real key, the biggest pitfall that I see when I talk with potential clients is too many of them have waited too long to talk with an attorney. And for both copyrights and trademarks, there are some times that people can do those themselves, especially with copyrights. But I run into a lot of people who used, a discount service or tried to do something themselves. And my rule of thumb is for me to sort of undo whatever they did and then do it correctly. It's probably going to be roughly 3 times as much in fees as it would have been to do it properly the first time around.
So like a lot of things in life, if you do it right the first time, it's going to save you time and money and a lot of frustration.
Well, it's sort of like the old Fram oil filter commercials. You can pay me now or you can pay me later, with the caveat that the pay me later is usually going to be a lot more.
Exactly. Well, Mike, it's been great talking with you today. I appreciate you coming on the show. If anybody wants to get in touch with you, what's the best way to do that?
The best way is to go to my website, which is Steger, Steger-law.com. And all my contact information is there. And feel free to call or email me if you have any questions.
Great. I'll also put that in the show notes. So until next time, I'm Gordon Coyle, the host of the New York Business Leaders Podcast. Thank you, Mike Steger, for joining us today.
Thank you.
Have a great day. All right. See ya.
Bye.
That's it for this week's episode of the New York Business Leaders Podcast. Be sure to subscribe so you don't miss next week's episode. In the meantime, find more interviews and resources at nybusinessleaders.com.